following program on Other Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the civil law aspects of money recovery. Can Sri Lanka's legal framework ensure justice for creditors while balancing the rights of debtors? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal topics and break it down for the layman. Tonight's topic is on money recovery, specifically the civil aspects of that. And to talk about this very vast topic, we have someone that's very well suited for this program, and that is Mr. Perumpuliarachchi, attorney at law. Sir, thank you very much, Mr. Perumpuliarachchi. Thank you very much, sir, for taking the time to come to our studio today and actually break this topic down. I believe we have a lot to cover as well and a lot of ground to break. So looking forward for the discussion. A little bit of an introduction on Mr. Perumpuliarachchi. He is an attorney at law, of course, and the former zonal vice president of the Bar Association of Sri Lanka. He's a former president of the Matra Law Society as well. So safe to say we have a lot of expertise in this area when it comes to breaking down this topic expertly for us to understand. A little bit of an introduction into how we're going to break down this topic. First, we'll be getting into the very basics of money recovery in the civil aspects. Next, we'll be talking about the current context as well as challenges that we can see come up. And finally, we'll be talking about potential future changes that we could expect in the legal field when it comes to money recovery's civil aspects. All right, well, without any further ado, let's get right into this very packed discussion. So once again, thank you very much. We have a lot of ground to cover, but before we get into any of the specifics about the areas relating to money recovery, civil aspects, I think I'd like for you to break down for our viewers exactly the basics of money recovery when it comes to the civil areas of it. Could you please give us a little bit of an introduction into what money recovery really is in the Sri Lankan context?
Yeah, in the Sri Lankan context, in fact, money recovery stems from contracts of money lending generally. So money lending contracts could be either verbal or even written. So now the various procedures have been created by law for quick disposal of business, and that's why the area has become vast. So I think we'll have to discuss the procedures as well as the limitations, etc.
I think when it comes to the limitations as well as the procedures, one of the most significant aspects that we see is, of course, letter of demand when it comes to money recovery. Could you please explain to us how exactly letters of demand and specifically the non-reply to letters of demand actually triggers this process and impacts certain legal proceedings when it comes to money recovery?
Yeah. Now, there's great significance in the letter of demand because, firstly, some of the contracts require the demand for the cause of action to arise. Some contracts state within a certain period or on a particular day the money has to be paid. But some contracts, for instance, in the case of a simple promissory note, it has to be on demand only, it has to be paid. So therefore, the cause of action arises upon demand, so the letter of demand is significant that way. At the same time, unless it's demanded that way, of course, if you straight away go into litigation, of course, the question of cost of litigation also will have some impact. So that has that significance. At the same time, the contents of the letter of demand, one must be mindful to reply, because there are authorities which say that silence or non-reply to letter of demand tantamounts to admission of the contents. But the recent authorities, I'll later cite, say that it's one factor only. But considering all the circumstances, actually whether the plaintiff's case or whether a case is established has to be determined. But so it's healthy for a defendant to reply.
Right, replying to a letter of demand is one of the most essential aspects of ensuring that there is no sort of, I would say complications to the proceedings as well. Moving on, sir, when it comes to the territorial jurisdiction aspects as well now, when it comes to territorial jurisdiction specifically, how exactly do we determine such actions under money recovery when it comes to Sri Lankan law specifically?
Basically, it's section 9 of the Civil Procedure Code that covers that area. Action for money recovery or any other civil action can be filed in the area where the defendant resides, where the cause of action arose, where the contract was entered into, basically. But as per the new amendment, Act number 43 of 2024, now you can even the area where the plaintiff is residing can be considered. So those are basically the areas, the criteria when considering the territorial jurisdiction. So then as to where the cause of action arose, it's the next issue.
Right.
Yeah. So shall I elaborate on that?
Yes, please, sir.
Yeah. The cause of action is really in money recovery actions is non-payment. So where the contract is was to be performed and non-performance. So then there are as you know, the law governing the general law of Sri Lanka or the common law of Sri Lanka is Roman Dutch law. So the Roman Dutch law principle is that debtor has to seek the creditor. Yeah. Therefore, then the debtor has to go after the creditor and ask for the money. If he doesn't pay, well, it's the area where the creditor. So I'm sorry, the creditor has to go after the debtor.
Right.
Yeah. And really, we are in the area where the debtor has not performed, having gone to the debtor if he has not paid. It's that area which is considered as the area where the cause of action arose. Then, where certain statutes, for instance, I'd say section 98(2) of the Bills of Exchange Ordinance. Certain statutes say specifically the area covered by that particular statute is governed by the English law. So in that event, the debtor has to seek the creditor. Then debtor has to go to the creditor and pay. So if there's no payment, non-payment arises at the place where the creditor resides. So that is the area. And also, some contracts state as to where actually at what place it should be performed. So where it's not performed, non-performance is at the place where the contract stipulates. So it's that area which is considered as the area where the cause of action arose.
Right, and speaking about the fact that this is the process under Roman Dutch law specifically, I think I'd like to ask you a question of curiosity, sir, which would be the key differences, if you could elaborate, between the Roman Dutch law practices and also English law when concerning the jurisdiction when it comes to contract enforcement, sir.
Yeah, that's what I checked.
Right. I want to get a little bit more of an elaboration when it comes to the inclusion of the new amendments as well. If you could give us a little bit more insight and detail when it comes to the differences.
Yeah, the difference in the sense, as I stated earlier, the common law is Roman Dutch law, and the English law is introduced by various statutes. So when it comes to performance of the enforcement of the contracts, as I stated earlier, it's the Roman Dutch law which should be followed invariably unless the statute states so. So where the statute states that the English law should be followed, well then as I earlier stated, then the cause of action arises at the place where the creditor resides. So that is really the distinction as regards enforcement of contracts.
Right. And sir, when considering statutes as well, now when it comes to the civil procedure code also, if you could give us a little bit of an insight into how exactly the civil procedure code acts when it comes to the regulation of filing and also the handling of money recovery cases in Sri Lanka.
Yeah. Now, when considering the civil procedure code regarding filing of action, generally, it should be as you know, the section 7 of the Civil Procedure Code introduces two procedures. That's summary procedure and regular procedure. Summary procedure is generally it's by way of a plaint and answer. Then in the answer there can be a claim in reconvention. Then there's a replication filed by the plaintiff. That is, claim in reconvention is something like a plaint against the plaintiff by the defendant. So then of course, then now in the present context, then there will be the pre-trial conference where there's the step called pre-trial conference. So before 30 days, you file your admissions based on the pleadings. That is, as to what points you agree, all parties agree, as on what are the matters to be, issues to be determined, issues and documents and lists. And that is the normal regular procedure. But as per section 8 of the Civil Procedure Code, if a statute states that the procedure should be summary, it should be summary. But that is where, in fact, the petition affidavit is filed and then objection, order nisi, etc. But then, now in respect of money recovery, there's a special procedure that is from section 701 to 711 of the CPC, where the money summary procedure is introduced, where a plaint is filed with an affidavit, with the documents. Generally it's on a bills of exchange, promissory notes, then checks, etc. So when you file that, you have to make sure that the necessary instrument is filed along with the plaint, and the court, if is satisfied that the instrument doesn't, so there's no suspicion arises, and it's properly stamped, there's no erasures, etc., the court will issue summons under section 9, article, the form 19 of the CPC. Then the defendant, there of course it's a mix of regular and summary procedure. Then the defendant comes forward and asks for leave to proceed, appear and defend his case. So he'll have to file an affidavit stating his defense. So if the court finds that there's a prima facie sustainable defense, well, court may allow the defendant to sort of appear and defend without security even. Otherwise, probably court might ask the defendant, if the defense is looks not sustainable, court might ask not to deposit the amount paid for, or a lesser amount, or to keep another security. So then of course from there onwards issues are framed and the case proceeds to trial. Then of course there are other procedures like debt recovery, small claims procedure. So they are all, now for instance debt recovery is more summary procedure, where you file, but there also the plaint is filed with an affidavit, and then decree nisi is issued, and then again similarly the defendant has to come forward and ask for leave to appear and defend. And if there's no prima facie sustainable defense, court will make the decree absolute then and there. Otherwise, he will be allowed to frame issues and proceed with his defense. Of course, in debt recovery, he'll definitely have to pay a security. Then small claims procedure is also there, No, that's a newly introduced procedure where a plain an affidavit is filed with all documents relied on by the plaintiff. And then in the answer, also the defendant also files all the documents he's relying on for his defense with an affidavit. So based on that, the court will probably, if parties consent, enter judgment considering the two sets of documents. Otherwise, court will record admissions, and in specials, if it's necessary, will raise issues also, and parties will have to seek permission for oral evidence and further documents to be adduced. So ultimately, the judgment will be entered. So that is generally the procedure for money recovery in Sri Lanka.
So that was quite comprehensive when it comes to the procedural aspects of filing for money recovery and what exactly happens. Viewers, of course, at home would very much be willing to understand how exactly it happens once you have to file a money recovery case as well. We do have to get into the arbitration and mediation aspects of money recovery in the civil sense as well, sir. But before we do that, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back after this. Welcome back to Law, Land and Liberty. We're in conversation with Mr. Chandima Perumpuliarachchi, attorney at law. So thank you very much for the previous segment. We were just discussing the very basics and the procedural aspects of money recovery in the civil sense when it comes to of course, the very basics. We just got a little bit of an introduction, a little bit of details, but we have to get into the specifics now as well. So I'd like to start with one of the more interesting areas of money recovery when it comes to the flexibility aspects of this entire subject as well, and that is on the arbitration. What exactly does arbitration play as a role when it comes to arbitration clauses specifically, when it comes to money recovery cases, and when it comes to the jurisdictions of courts? How exactly do these clauses affect it?
Yeah. So arbitration, as you all know, it's a outside court process for conciliation or settlement of commercial disputes. So nowadays, most of the contracts contain an arbitration clause. So one has to be very careful to see if there's an arbitration clause before filing an action, because if there's an arbitration clause, of course, firstly, you have to go for arbitration before filing of the action. As per the section 5 of Arbitration Act number 11 of 1995, so if you file an action where there's a arbitration clause, and if it is if the matter is not referred to arbitration, if only the other party takes up the objection, the court will lose its jurisdiction. So that will be the real impact on arbitration clauses to court cases. Yeah. So
moving on, sir, when it comes to, well, we have to talk about the specifics when it comes to mediation as well, relating to arbitration, of course. But a little question when it comes to money recovery specifically, the Debt Conciliation Board. Yeah. How exactly does its influence into legal processes actually play out when it comes to money recovery, sir?
Yeah, now debt conciliation is a process really outside court. Anyway, it's a tribunal outside court. Debt Conciliation Board. Debt Conciliation Boards have jurisdiction to arrive at settlement and sometimes make determinations also on debts which are secured by notarial instruments. Where the debtor or the creditor can make application to the Debt Conciliation Board for a settlement, and under section 37 of the Debt Conciliation Boards Act, of course, even a determination can be made. So now there, of course, what is secured of course, what has been determined has been interpreted to mean any contract where there's a notarial instrument sort of which really gives which is given as a security. So it can be nowadays I have seen sometimes debt conciliation boards go into the question whether a transfer deed is actually a transfer, or it's only the beneficial, while keeping beneficial interest, it has been kept as a security for a loan only. That is a constructive trust. Even that is considered, and ultimately determinations are made for the debtor to redeem the debt, probably in installments sometimes, and for the creditor to transfer the property even. So they have exercised their jurisdiction to that vast extent, and the irony is there's no procedure for appeal. Since it's an administrative body, you can ask for you have to.
What does that play out for the affected parties, sir? The fact that we don't have the appeal process as well.
Yeah, then that's what I was telling. So you'll have to go for invoke the writ jurisdiction of probably the provincial high court or the court of appeal to quash the determination. So one has to be very mindful. So if the debt conciliation board makes an sort of sends you a notice, if you are the debtor or the creditor, you have to rush. Of course, you can't ignore, because since it's not a summon from a court or something, you must not neglect it, because in your absence there could be a determination against you sometimes. Then that particular determination, of course, comes in the form of a certificate by the chairman of the debt conciliation board, and it can be present to the party whoever the party who wants can present it to the district court, and then get it enforced. So really a decree nisi is entered the moment it's tendered, and the other party, the opposing party, is given an opportunity really to file objections. But then the decree could be made absolute thereafter. Right. So the other matter, I think, debt conciliation, when the matter is referred to the debt conciliation board, of course district court cannot sort of question or take up the same question in a court case. Also the validity of determination of the debt conciliation also, or the procedural validity of the debt conciliation board, those aspects cannot be considered by the district court.
Moving on, sir, now I wanted to touch on this earlier as well, mediation board certifications when it comes to money recovery cases, then the filing of money recovery cases. Could you elaborate on that aspect? How exactly has its process evolved over time?
Yeah, the mediation board process is a procedure which is there to sort of to resolve disputes between parties in a faster manner with less cost, and to reduce the workload of court, because they try to bring parties into a settlement. So when a matter is referred to the mediation board, if the parties arrive at a settlement, of course the certificate of settlement will be entered. Otherwise, if there's no settlement, certificate of non-settlement will be entered. So if it is certificate or non-settlement, so as it is now, as per the Act number 2 of 2024, the section 7 of the Mediation Board Act has been now amended to to make the limit as rupees 1 million. So if the value of the action, even for money recovery cases, is below rupees 1 million, well, you have to first refer the matter to the mediation board and obtain the and if the matter is not settled, court will issue, the mediation board will issue the certificate on non-settlement, and then only you can file action. So earlier as per the Act number 4 of 2011 up to 21st January 2021, the value was 21st July 2016. The limitation was rupees 215. From there onwards, up to the present amendment, it was rupees 500,000. So gradually, the limit has increased. So accordingly, unless you have obtained the certificate on non-settlement, well, you can't file action before the district court. And also, if there's an interim application, if you ask for an interim injunction, or some, so then the matter, as the matter is urgent, considering the urgency, you can straight away file the case for the case in the district court without referring the matter to the mediation board. But once the interim application is concluded, the court will have to refer the matter to the mediation board for settlement. Then only court will have jurisdiction to consider the main case. So, yes.
So that is basically the mediation board has a bit of an integral role when it comes to actually taking some of the burden off of the court process as well when it comes to resolving these issues, which is essential. I want to ask you specifically about the effectiveness of including the mediation processes when it comes to money recovery as well. But before we get into those, and also a little bit on the money lending ordinance and in that specific area as well, how exactly money recovery plays out, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back with the final segment right after this. Welcome back to Law, Land and Liberty. We're in our final segment in conversation with Mr. Chandima Perumpuliarachchi, attorney at law. So thank you very much once again for the previous two segments. I believe we covered a lot of ground, got into a little bit of detail as well, but I had to stop you before we could get an answer to a very curious question, which is the role of the mediation board, of course. How exactly significant of an impact does mediation as a principle have when it comes to money recovery processes? Is it essential?
Yeah, in the sense, since it's a precondition in respect of disputes where the value is below 1 million, of course, it's a must for those actions of that category. But otherwise, if parties arrive at a settlement and if the settlement is honored, of course, the matter will end there. So to that extent, it will have a significance. But if the settlement is breached, of course, there's no remedy. Mediation board settlement, although a certificate of settlement is entered, that cannot be enforced. So that is the problem. So if it is not, if the settlement is breached, of course, the mediation board will then issue a certificate of non-settlement, the next step. So then again, you have to come to court.
Right, so a little bit of a fleeting process as well, yes. I'd like to move on to what I couldn't discuss in the previous segment, which is on the money lending ordinance. If you could explain to us the limitations that have been imposed through the money lending ordinance when it comes to the interest rates and also principal recovery.
Yeah, the section 5 of the money lending ordinance states that the interest that could be recovered in an ordinary money lending transaction cannot exceed the amount of principal. So one cannot ask for anything, the interest, accumulated interest, more than the principal. More than the amount of principal. So then the other thing is the interest rates. Interest rates, of course, I think now that you have asked in respect of interest rates, of course, certain rates, of course, now this is how, if the value of the principal is rupees 2,500 or more, the interest rate should be 15% per annum. But then this is an old law, so if it's between 2,500 and 100, it should be 18. It must be 18% or less. Then if it's the principal is 100 rupees, since this is an old ordinance,
right,
it's 25% or less. So anything exceeding those rates. Now in today's context, of course, no one will litigate for any amount below rupees 2,500. So it should be 15%. But it's not. But then, if the interest charge agreed upon is more than 15% per annum, of course, you can make representations to court that the interest rate agreed upon is reasonable. If court finds the interest rate agreed upon, though it's more than 15%, if it's reasonable, court will have discretion to probably accept the rate. At the same time, if 15%, say in today's context, of course, anything below 2,500 rupees, as I said, there will be no litigations. So if it's below, even the debtor can agitate to court that 15% interest rate even is not reasonable, should be reduced. So court has discretion. So as per money lending ordinance, those section 4 provides for those situations. So then the other thing is, there must be regularly, if it's an ordinary money lending transaction, if the person who lent money is a professional money lender, he has to have maintained regular accounts. So if it is established he has not maintain regular accounts, of course, he won't be able to maintain a money recovery action. So those are the limitations.
These are the limitations. Now, specific area in money recovery, specifically when it comes to financial institutions, so there's a little bit of a distinction, of course. How exactly now acts like the Debt Recovery Special Provisions Act, how exactly when considering financial institutions, does such acts like these aim to streamline the process?
Yes, because those acts have come into being for quick disposal of business. For instance, debt recovery law, as I stated earlier, that is a special procedure for certain licensed commercial banks, state mortgage bank, NDB, National Savings Bank, DFCC, and other finance companies which have been registered under Finance Companies Act number 78 of 1988. So then the amount in default must be rupees 150,000 or more. So if those criteria are satisfied, of course, that institution can file a debt recovery action. As I stated, and the other thing, there must be a written contract. It's a must. So the plaintiff has to really, you wanted the procedure or the... Yeah,
procedurally, how exactly does it hope to streamline the process?
Then, of course, plaintiff company or the institution will file action with an affidavit, which the affidavit has to be signed by a principal officer or a director. And then the court, if court is satisfied, with the affidavit, all the documents which the plaintiff relies upon will have to be, especially the instrument upon which the plaintiff, as I stated, there must be a written contract. So if court is satisfied that the debt is actually due prima facie, court will issue a decree nisi. Then that will, then the other way, earlier, of course, as per the civil procedure, it has, summons were to be served through fiscal. Now, in this case, of course, serving it through registered post would be sufficient. Then the defendant, he has to come and ask for leave to defend and appear. So for that, he must file an affidavit, all the material supporting his position, his defense, and it must appear to court on the material presented by the defendant that there is a prima facie sustainable defense. Then only court will allow the plaintiff to proceed with his appear and defend. Otherwise, if for instance, if there are only technical objections in technical nature, if there is no prima facie sustainable defense, well, then court will make the decree nisi absolute straight away. So it's not a long process in that sense.
A bit more expedited.
Yeah. Only if the defendant has come out with such defense only, there also he is a must for him to furnish, either pay the amount asked for or sum determined by court, or furnish a security before defending, appearing and defending. So then the court will allow parties to frame issues and proceed with the trial. So this is really a filtering process at the outset. If it looks to court that there is no case to the defendant, or even the plaintiff, if plaintiff is not satisfied with the plaint presented, with the material with the plaint, of course court will not proceed with it. So it's quick disposal of business.
Right. It's to specifically, as you mentioned, a little bit of a filtration as well. Not just that the procedure is expedited, but it's also going to deter any sort of non-cases from popping up in the court system as well. I want to ask you about the defenses that debtors may have when it comes to money recovery cases. But before we get to that, you touched a little bit about the fact that it has to be a written contract. So I'd like to ask you on that note, sir, when it comes to the role of written and verbal contracts, how exactly do these two different contracts, the verbal and written, actually determine the period of filing recovery actions?
That means the limitation.
Yes.
Prescription. Yeah. The written contract, or in respect of written contract, from the date of cause of action, you have to file action within 6 years. Section 6 of the prescription ordinance stipulates that. Then if it's a sale of goods contract, it's 1 year from the date of cause of action. Section 8 of the prescription ordinance stipulates that. Then if it's a mortgage, if you based on a mortgage, if you seek to recover, of course within 10 years of the cause of action you can file it. But then the section 10 of the prescription ordinance states, in respect of the contracts or matters which are not dealt with in the act, of course the period of limitation is 3 years. So verbal contracts come into that category. So it will be 3 years from the date of contract if it's a verbal money lending agreement.
Right. Now I'd like to move back to the point that I wanted to really elaborate on, which I believe viewers would also find very interesting to understand, the defenses that debtors are owed when it comes to the money recovery cases, specifically considering prescription and jurisdiction. So if you could please give us a little bit of an explanation.
Yeah. If one takes up the defense of prescription, it's a must that he pleads prescription in the answer, or whatever suppose you seek leave to appear and defend under the new procedures, etc. So prescription must be specifically pleaded, otherwise you can't take up prescription in the case. Then as regards defenses, of course the other one is jurisdiction. If court has no jurisdiction, maybe the matter is not referred to mediation board, maybe court lacks jurisdiction due to territorial limitations, or so whatever it is, jurisdiction also must be in a defense. In an answer, it must be specifically traversed under section 6 of the Civil Procedure Code. Jurisdictional objections also must be specifically pleaded or traversed. And the other objections mainly, of course, if you sue on a written contract or you base your case on a particular document which is in your possession or power, under section 50 of the Civil Procedure Code, when case is presented, it must be presented with the plaint. For at least a copy must be annexed to the plaint, otherwise the case can't be proceeded. And also, the cause of action, you must specifically mention the time the cause of action arose, where it arose, because for the purpose of determining the jurisdiction, whether any amount is paid or the total amount is paid, whether the plaintiff is sort of concealing certain facts regarding payments. That kind of, those are basically the sustainable defenses, of course. Yes, those are basically the sustainable defenses in a defendant's case. Yeah.
And moving on, sir, when it comes to overdraft facilities and also when it comes to prescription of debt related to such overdraft facilities, could you please explain to us what provisions exist in that area, specifically when we come to handle cases of overdraft facilities?
Yeah, overdraft facilities are also, they could be either now when it comes to a bank, of course, sometimes if the customer is a reliable person, he has maintained good sort of relationship with the bank, of course, without asking him even, court will allow him to overdraw, even if the monies in the accounts are insufficient to honor a check, court will honor. So there, of course, it's a really, one can't say it's a verbal contract, because presentment of the check and bank paying for that check, the check it's a written request to honor, so it's a written contract. So it should be 6 years. Then otherwise, permanent overdraft facilities are, of course, granted by way of written contracts. So it should be again 6 years. So as to when the cause of action arises is the issue. Now, as per the recent authorities, once the money is overdrawn, the cause of action arises unless the contract makes a special arrangement for the repayment, maybe on demand or something. If the contract doesn't stipulate, by overdrawing the cause of action arises. So that is the position. Yeah.
Right, and
from there 6 years.
Right,
yeah.
So 6 years from that point. Right. Validities of a contract, when it comes to situations where such a validity of the written contract can actually be challenged, especially when it comes to, of course, drafting issues and the lack of explanation when it comes to the time of signing as well. How exactly is that area really handled?
But if because this is a very common defense, which is not accepted mostly by courts, because one goes to the bank and he says he signed the papers and he didn't read, or there were blanks papers, or so anyhow, it's your responsibility. If you go and sign, of course, the content, you are bound by the contents. So unless the contrary is proved, that it will be very difficult, unless the contrary is proved that there were blank spaces, or this he was asked to sign, really when he signed it was a blank paper and it has been subsequently prepared,
but we need to be knowledgeable about that fact.
Yeah. So that will be, but the law is that once you sign, you are bound by the content. Yeah.
Exactly. So we have to sign with mindfulness and understanding of what exactly we're about to partake in an agreement of. Moving on, sir, when it comes to the Debt Recovery Act, if you could explain to us how exactly applications for leave to appear and also defending cases that are filed under this act are actually handled by the courts?
Yeah. Then once if a prima facie sustainable defense is disclosed, of course, court will allow him to, depending on the sort of sustainability, court will probably ask to pay a lesser amount, sometimes the full amount, right, sometimes the security, and then of course the parties will have to, then court will allow the parties to raise issues and proceed with the trial. So ultimately the court will enter judgment accordingly. So after this filtering process I stated, the court will hold a normal trial, which will be a regular trial thereafter.
Right. So yes, ultimately the filtration process that is employed by the Debt Recovery Act is quite effective when it comes to ensuring that proper cases are put through to the legal system.
Yes.
Right. And I'd like to ask you as well, sir, when it comes to the practical application of this law, specifically when we see case law that has developed in this area, could you please let us know if there's any specific key case laws that people can actually refer to when it comes to the application of this law?
Yeah. Now, for instance, now I would like to refer to this judgment of D.M. Chandrapala Meegaharava versus D.M. Samaravira Meegaharava. This is a judgment by Justice Mahinda Samewardena, or His Lordship Justice Mahinda Samewardena. The reference is SC Appeal 112/2018. That is the judgment which states that where even if you don't reply to letter of demand, that is only one factor where one can be where it can be considered that he has admitted the contents. But it has to be considered with the other factors also, and ultimately decide whether the case is established by the plaintiff. So then I would like to refer to this is rather an old authority, but still it's often cited, Brampiappuhami versus Gunasekara, 50 NLR 253, which states that prescription is a defense that must be specifically pleaded because it's a question of mixed fact and law. Therefore, it must be specifically pleaded. Then and also I would like to refer to this judgment of in respect of the overdrafts.
Yes.
As I stated, the overdraft, of course, once the money is overdrawn, the cause of action arises in the absence of a special arrangement that overdraft dues are payable on demand in the contract. So limitation will begin from the promise or the limitation will begin if it's a written contract after 6 years.
Right.
Otherwise, really it's after 6 years. The judgments are Gunawardena versus Indian Overseas Bank 2001, 2 SLR 113, and HNB versus Helen Luck Garment 1999, 2 SLR 365.
So we can see that there are various case laws that we can refer to where the actual actionable practice of this piece of legislature actually really is practical, and we see it delivering justice for people and institutions as well. Unfortunately, sir, our time here with you today has come to an end. I believe there's a little bit more specifics that we could have gotten into and detailed discussion, but unfortunately our time constraints will have to end our program right here. Thank you very much, sir, for taking the time to explain the surface level and also a little bit of the intricacies of money recovery in the civil sense. Thank you very much for your time.
Thank you, Anurag.
All right, well, we'll leave you tonight with the words of linguist and Professor Noam Chomsky. Debt is a social and ideological construct, not just a simple economic fact. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/otherderana English. Thank you very much for watching. Have a good night.